Hi, y'all, and welcome to tonight's live stream. Well, at long last, on the 29th day of a trial that has spanned 8 weeks, the state rested. More than 60 witnesses for the state. We started on April 29th. It's now June 21st. And we had the final witness for the state. The defense then moved to have the charges against Karen Reed dismissed. That took maybe 20 minutes, but we're going to cover it because it answers a question a lot of you have. And then the defense began its case. We had a my cousin Vinny moment. It actually happened. So we are going to cover it all tonight. And then we're going to wind up. We're going to do some video clips. I'm going to kind of walk you through the day. And then we're going to have a look at the timeline. And we're going to add in today's events and see how they fit in with the other things we know about. So welcome in everybody. The first 5 who haven't been named, first 5 into the chat who haven't been named yet this week are Bonnie's Fun Stuff, Connie Unmocked, Susan Moore, Miss Construe, and Neuropsych Zeno. Welcome, special welcome to the 5 of you. We also have a winning contribution for the day on the AI that we were doing. You may remember I told you I am now obsessed with that AI summary of the live chat as I watch the trial. It is sometimes utterly hilarious. I'm going to show you Michelle's that she sent in, and I've got a couple more for the end for you too. But let's take a look at Michelle's. Prosecution rests its case, and Chris Albert is found not guilty. We're headed home, everybody. Chris Albert is not guilty. Case is over. The defense has 6 experts listed with 77 witnesses and intends to call them, except for one expert that the judge will decide on later. So obviously not what really happened, but Chris Albert, he's not even on trial. But according to the AI chat summary, he has been found not guilty. And the defense has 77 witnesses. We're going to be here a while if that's the case. So I don't think any of that is true. But anyway, it was pretty funny. Thank you to Michelle for sending that in. I really did appreciate it. Also want to give a special shout out to Steve. And everybody hit that like button for the video. It'll really help it get out to more people. If you aren't part of our group yet, please subscribe. We would love to have you back for more. So let's get started. Let's just dive in on the prosecution. The prosecution's case came crashing to a close this morning. On the stand was Dr. Scorty Bello, the medical examiner. But the case did not go out on a high note for the Commonwealth. In fact, I would say that this witness might be the very one who torpedoes the Commonwealth's case. I'm going to spend a little time on her testimony and sort of break it down so I can explain why I think her testimony matters so much. So no matter how hard the Commonwealth tried, she was basically unwilling to pick a side. She said the injuries could be consistent with anything. But watch closely and check out the body language on this next one. She is asked whether the head injury could have come from a pedestrian collision. Of course, that's what the state says happened. Does she really think it could? You'll see her answer. She's also asked whether the arm injuries could have come from a broken taillight. Again, that's the prosecution's case. The prosecution has put this witness on the stand and is asking her questions. But watch what happens. Let me add that to the story.
What, if anything, can you say about what that blunt object could be?
Could be any blunt object.
The injuries that you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then
watch
striking your
this.
head on
Watch her.
It's possible.
See what I mean? And cut to a different section.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
So in each of those, she's kind of like, well, I mean, I guess, maybe, kind of, but she doesn't really seem to think that's very likely. And that was a long way from being gung-ho for the prosecution. And she's our last witness. She's the big roundup, right? And to make matters worse, she was really clear with the jury today that this was not a typical pedestrian strike. Now, the state says Karen Reed ran into John O'Keefe with her car. Pedestrian strike. But she said it sure wasn't typical for one. Here's what she said.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no. When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs, because in the majority we see injuries to the legs from the bumper of the car. Again, depending on the kind of car, the size of the car, and the height of the bumper. So in Mr. O'Keefe, I did not see any injuries in the lower extremities.
So there's a problem, right? Because she's saying that normally in a pedestrian wreck, I would expect to see the pedestrian is going to get injured below the waist where the car hits them. I don't see that here, is what she's saying. And here on cross-examination, the attorney for Karen Reed is going to circle in on that.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. And you testified that these also sort of appear in clusters or groups. You call them pattern abrasions. Is that right?
Yes, I did.
And you'd agree that, for example, road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
And I'm
And
cut
you've
a
seen
bunch here.
numerous cases of road rash in your
Yes.
career. And it doesn't look like that.
Correct.
Would you agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour?
I would say it's likely and unlikely at the same time, depending on the position of the body and the vehicle in question. I am not a reconstruction expert. I'm not a biomechanics expert.
So the witness, Dr. Scorti-Bello, left it open for a biomechanics expert, a kinematics expert, a reconstruction expert to fill in the gaps and to explain exactly how the accident happened. The problem is that the witness the state used to do that did not hold up well on cross-examination. That was Trooper Paul, who did the reconstruction. And so now that means this area is left wide open for the defense reconstruction experts. And there are two of them. We know from the voir dire that was done on them that they're polished, that they're professional, but we don't really know what exactly they did. Did they do testing? Did they do a computer simulation? We don't really know what exactly they did, but we'll wait and find out. That'll be coming next week. So as for Dr. Scorti-Bello, she was willing to say all of the injuries could have come from John O'Keefe being punched. Well, that goes right to the heart of what the defense says happened in this case, because the defense says that John O'Keefe went into the home there at 34 Fairview and somebody in there attacked him. They punched him, did something to him, and then they put him out in the snow to try to frame Karen Reed, to try to get him out of the house and to take the blame away from what they had done. So that is exactly what the witness, from the prosecution's point of view, what they would not want the witness to say. But she's willing to say that these injuries could have come from being punched. So let's listen to what she said.
Injuries to John O'Keefe's face. Would you agree that his injuries to his face are consistent with having been punched?
That is a possibility.
Your internal examination notes also cite a tongue laceration on the right front of the victim's tongue. Do you recall that?
Yes.
And you'd agree that a tongue laceration can be also caused by blunt force trauma.
Correct.
And that could also include something like a punch to the victim's face or jaw.
That's a possibility.
You testified that the skin around the laceration on the back of his head was also scratched. Would you agree that someone could certainly get scratched on the back of their head if they were, for instance, dragged on the ground?
It's possible.
And you'd agree that bruising to the backs of hands is also consistent with defensive wounds?
And she said, that's correct. But the witness was not willing to say specifically how Karen Reed got that head injury. So she was willing to say it could have come from a punch. She was willing to say these could be defensive wounds, but she wouldn't specify how the injury came about. She wouldn't do that on behalf of the prosecution.
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that right?
Yes.
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
It's possible.
It could also be the result of being struck with a large object such as a baseball bat or a barbell.
It's possible.
In other words, he could have suffered a trauma to the face and then fallen and sustained the injury to the back of the head, correct?
That is possible, yes.
And you testified before the state grand jury that the areas of bruising to the brain were likely due to a fall. Is that correct?
Yes.
So this was a long way from the triumphant exit that I'm sure the prosecution wanted. We waited a long time for the two medical examiners to come, and frankly, I was expecting a lot more from them. Now, I said last night that the jury can find a homicide even if the medical examiner doesn't. Several of you had asked about that, and that's true. They have different jobs. The medical examiner is looking at different things. The jury has access to evidence and information that the medical examiner would not. For example, the motive, the text messages, those sorts of things aren't going to really be relevant to the medical examiner, or she won't look at it as closely. The jury is going to have a lot broader view of the people and the parties that were involved. But here's the problem for the Commonwealth on this. This is, as anyone can see, a very contentious, disputed case. And the jury has to decide whether they believe the prosecution has carried its burden of proof. So they have to ask themselves, do we believe the Commonwealth proved Karen Reed was guilty beyond a reasonable doubt? So the jury has that threshold question they have to answer. Did Karen Reed hit John O'Keefe with her car at all? And the defense is saying it didn't happen. It didn't happen at all. There was no pedestrian strike. She never hit him with her car. So the fact that the medical examiner is not willing to agree that there was a pedestrian strike is more important in this case than it might be in another case. You can see how it kind of played out. We're going to go next into the motion that the defense filed to try to get the charges completely wiped out, to get the case dismissed. And we're going to kind of watch it play out. It's a very standard motion that they make that is at the end of the prosecution's evidence. It's just a typical motion. It happens in civil cases. It happens in criminal cases. It very, very rarely wins. And this case was no exception to the general rule. So before we play the first clip on that, I want to say thank you to Mitt Spunky for gifting a lawyerly membership. I appreciate that. And welcome, Stephanie, our new member. Okay, so first of all, let's talk about what the standard was. I said that this is very rare for the courts to grant these. So let's take a look. Here's how Jackson, the lawyer for Karen Reed, explains what the standard is.
The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury could find the elements of the charges beyond a reasonable doubt. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth.
So the defense has to actually argue that no reasonable or rational jury could come to a finding that Karen Reed is guilty. Given how contentious this is, that's a really hard standard to meet. It's a hard standard to meet in any case at all, ever. And that's why these are so rarely granted. It's commonly done by lawyers, but usually, I mean, for example, here they just needed 10 minutes. They said it wasn't something that they spent a lot of time or devoted much effort to. So, but Alan Jackson made the exact argument that I said, that the Commonwealth did not manage to prove that there was a pedestrian strike at all. And here's the argument that he made.
There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. The Commonwealth's entire case relies on a theory built on the shoulders of a trooper named Joe Paul, who testified a couple of days ago. And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck, he was spun around in sort of a pirouette, he was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. There's no evidence how getting hit in the arm could actually launch a body 30 feet, as per the Commonwealth's theory, and there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning. The evidence before the court, the only evidence that is before the court, is that the Commonwealth's own medical examiner does not believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries, and they are, every single one of them, consistent with a physical altercation.
So the reason why that's not going to win the day is because while the experts said, yes, that these are consistent with the physical altercation, she also said they're consistent with the prosecution's theory of the case, that this was a pedestrian strike. That means a rational, reasonable juror could decide that that's what happened in the case. And so the jury doesn't have the option of saying undetermined. They do in this sense, which is they can make a decision. They could have a hung jury where they literally can't decide. But if they are going to reach a decision, they can't just say undetermined. They have to say that find guilty or not guilty. And so in this particular case, the fact that the medical examiner was unwilling to come down on one side means it would be rational for them to choose either direction. And that one of the questions I got several times last night was people were wanting to know, okay, what can the Commonwealth possibly say in return to this? What evidence is there? And I pulled out that section for you because I thought you would enjoy hearing what exactly the Commonwealth is arguing. I've cut it down a lot. They had more, but I wanted to sort of just go through it with you. The first thing they argued is that there is physical evidence that could support the rational, reasonable juror who is deciding that this really was a pedestrian strike.
This case does not rest and fall with the testimony of Trooper Paul. So what the court has, as far as the physical evidence, next to Mr. O'Keefe's body, the one sneaker in the location of the curb, the glass, the drinking glass that Mr. O'Keefe is seen walking out of the Waterfall Bar at approximately 12:11 a.m. with, that is in the vicinity, the direct vicinity where the Canton police officers actually recover it early in the morning of January 29th. You have the microscopic pieces of the defendant's taillight, which was testified by Ms. Hanley to be consistent with the pieces of the taillight from the defendant's vehicle that are within or embedded within Mr. O'Keefe's clothing. You have the remainder of the pieces of taillight, and this part is important in relation to Trooper Paul's testimony as far as the linear momentum, and it's all in the same around the area where Mr. O'Keefe's body was. The testimony from Ms. Mix Valier, with reference to all of those taillight pieces and how they were able to reconstruct from the pieces that were found on the ground and then put back together, matching not only to that, but the taillight housing from the defendant's vehicle. You have the plethora of testimony from the various civilian witnesses from that particular night. You have the evidence of motive from the text communications. There are arguments that continue throughout the afternoon of the 28th and seemingly into the 29th. You have the defendant's own statements that I hit him, that come from multiple sources. You have her statements to the paramedics in the back of the ambulance that the last time that she saw Mr. O'Keefe, they had gotten into an argument.
So let me back that up. I got a message from YouTube saying they were having, or from StreamYard saying they were having trouble streaming to YouTube, which freaked me out, but it looks like everybody's still here and nobody is saying that I'm gone. So when you think back over what he just said, he's saying there was physical evidence to support the idea, our position, that it was Karen Reed who hit him. You've got not just pieces of taillight, and we know Karen Reed has thrown some cold water on that and said that they believed these were planted there, that they weren't there naturally, but that they were planted there. They were also found embedded in the clothing that John O'Keefe was wearing. That would be harder for the police to create or to frame Karen with. And then they were in a line going in the direction from where the prosecution says he would have been hit over to where his body was. So they're saying if you look at those things put together, then you have some physical evidence to support it. And you also have some motive evidence. You've got some evidence that shows that they were fighting and arguing that very day, not just in general, not just having a rocky relationship, but they had actually been having a fight that very day. And she mentioned that to other people. So with all that, there was pretty much no chance that the court was going to just dismiss this outright. It doesn't mean that the Commonwealth is likely to win the case. It's just normal. And the judge, she didn't bat an eyelash. She didn't stop and think about it. She didn't take it under advisement, which she does for a lot of rulings. She just said no. And we moved straight into the defense case. So that happened pretty much right away. So I wanted to make a comment about Nikki Johnson. First of all, thank you for the super chat, Nikki. And she says respect to the medical examiner for sticking to her professional ethics and not pressure. And I just want to say, I really do agree with Nikki on that point. It would have been difficult, I think. And there was the discussion between Trooper Proctor and another trooper who was saying, hey, how could you possibly not have gotten the medical examiner to say this was homicide? What's wrong with you? I could have done that. And Trooper Proctor tried to pass it off as just somebody giving him a hard time. But that really was something that would have been real pressure and not just pretend or imaginary. And so I think she stuck to exactly what she thought, and she answered it just the way she thought was correct, which sort of went straight down the middle and left everything open for the parties to make their argument. So I admired that too. And thank you, Char. I really appreciate that nice message. Thank you, and for the super chat. So the first witness out of the box for the defense was the snowplow operator. We'd heard about the snowplow operator in opening, but didn't really know much about what would be said. And here is where we had the my cousin Vinny moment, although maybe it'd really be better described as an my cousin Vinny moment. So he knew the snowplow. I'll just sort of intro it for you and then tell you. He knew all the Alberts, including Brian Albert, who owned the house there at 34 Fairview. He even worked for Chris Albert, Brian's brother, as delivering pizza for his pizza shop. And now his job was working with the city as a snowplow operator. And he drove a snowplow nicknamed the Franken truck. So since a blizzard was underway, he was on duty in the early morning hours of the 29th, and he drove down that road plowing. So the defense point is, why didn't he see John O'Keefe lying in the snow outside the Alberts' home? If Karen Reed hit him at 12:30 a.m. or so, then why did nobody see him when they left at 2 a.m.? And why didn't the snowplow driver see him when he went down the road at about 2:30 a.m.? The snowplow driver, in fact, testified that he went down the street twice. We're going to plug this, by the way, into our timeline. We're going to save that for the best for last. We're going to be doing the timeline and looking into that. So hold on, and I'll give you some exact times, and you'll see it fit into how the case progressed, all the evidence put together. So he said he had spotlights illuminating all around him. He could see a wide scope of area, and yet he never saw a man lying in the snow. But what he did see that second time he went by was a Ford Edge, which is a model of car that some of the Alberts drive. Now, the Ford Edge was sitting right by the spot where John O'Keefe's body was going to be found the next morning. He remembered this because it was in his way. He had to go around it. It wasn't supposed to be there. And he said the Alberts didn't normally leave cars out. They normally thought about the snowplow issue. So the cross-examination was sort of tantalizing, but not very satisfying. It sounded as if Lally was trying to say that this witness had spoken to a man named Paul, different from Trooper Paul. Apparently, this Paul was an investigator working for Karen Reed, although we never got a firm answer on that. And the witness, the snowplow operator, told this Paul that he came into work at 11:30, not 2 a.m., which is what he was testifying to today. But we didn't have anything to cross-examine him with. That's just sort of where the questioning suggested. And that wouldn't have been as favorable for Karen. Think about it, because it would mean that the snowplow driver might have been there before Karen and John even got there. They didn't get there until after midnight. According to the questioning, he also told this man named Paul that the snowplow operator had seen a black SUV, not a Ford Edge. Again, that would fit with the prosecution case. That would just mean it was probably Karen Reed there with John O'Keefe, but not the Ford Edge. So it sounded like this was maybe something that would come out in rebuttal, but at this point, the witness denied having said that at all. So we were left with just sort of confusion around what the questioning was. I am really curious as to whether the prosecutor is planning to call the defendant's investigator in rebuttal. That would be very unusual and pretty dangerous. So I'm really curious if that happens. Now, the prosecution pointed out a couple of things with this witness, like the fact that he remembered lots of times very precisely, but there was this one incident that very night when he actually hit a basketball hoop, but he couldn't remember when that was. And he did report that to the city, unlike the fact that he did not report the Ford Edge being parked in the road, even though technically he was supposed to. He said he was doing the Alberts a favor. So all of that made the My Cousin Vinny moment kind of even more interesting. As I said, maybe more My Cousin Vinny. So here's what happened, because it's in Karen Reed's interest that this guy be credible about what he saw or didn't see. They need him to say, I looked, I saw no body. I looked, I saw a Ford Edge. And people need to believe him. So what he sees or what he doesn't see is really critical to the point of having him testify. But here's what happened during the questioning.
It's hard to decide to put into words, but I can see a real long distance. That visibility is fine. It is extremely. If you gave me probably 5, 10 feet, 15 feet out, maybe even further.
Okay. And with regard to the lighting, how much light does that give off?
It's trucks.
Enormous amounts. It's almost driving with the spotlight.
And here's a cut to the part that I was talking about. Give it just
in terms of is it you can't read the writing or you can't really see the outline of the streets?
Both.
Okay. Well, that's not going to help much. Okay.
I believe that.
So, and I'll stop it there. But what was really interesting was the defense attorney, Yannetti, left the map up saying, well, the jury can see it. So obviously this witness had worse eyesight than Yannetti believed the rest of the jury did. So I thought, well, I'm not sure that this is helpful for their case. It seems like it kind of undercut it. So we then went to the first defense expert of the day. It was Dr. Marie Russell. She was the one who was very hard fought by the prosecution. They wanted her out. They didn't want her to be able to testify. She's a medical doctor, and she has written papers on dog bites. She's an emergency room forensic pathologist, recently retired. She was the chief medical executive for the state of California and a state prison, 16 years of formal education beyond high school. She was also a former police officer, and she had written a couple of articles on dog bites from police dogs and of the injuries that police or victims, any victims, would receive from that. So here's what she had to say about John O'Keefe's injuries?
These injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe for the jurors, please, on what you base that opinion?
Yes, there's a number of patterns here. There, up on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of parallel marks. Again, probably most likely from teeth marks. And the reason I say that is, in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below, some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. And then there are some irregular wounds down just below the elbow. And these are all, by the way, on the exterior surface, or what we call what doctors would call the posterior surface of the arm, which is the part of the arm that would sustain defensive type wounds.
Just to clear up what you said a little earlier about some of the wounds close to the elbow, is it your opinion that both the top teeth and bottom teeth could have created some or all of the injuries on that elbow area?
Yes.
So I honestly thought that Dr. Russell was less impressive than she was when she appeared on the voir dire in front of just the judge. The jury never saw that. We saw that because it was broadcast, but it wasn't shown to the jury. And the reason I thought that was because Jackson didn't really go into her background on the dog bites issue. And the judge may have limited what the defense was allowed to talk about in that connection. But I really did think that her information about the articles she had written that were peer reviewed related to dogs, and she at the voir dire talked about the fact that she had seen one of the studies had 700 different dog bites that they looked at. And to me, that sort of gave her a whole lot of credibility. I think she was credible anyway. I just thought they missed an opportunity to talk about what she had done specifically with dog bites. There was very little about that. So the Richard Green then testified, and well, let me go ahead and say, Jen Ken is talking about how exactly the wounds on O'Keefe's arm are made and suggesting maybe they came from a different source. I really appreciate the super chat. Thank you, Jen. But I don't know for sure. I don't have any information about that. The only evidence I know is what the defense presented at trial, which is their belief that those injuries came from a dog and that there was a dog attack. That was their expert, Dr. Marie Russell. In terms of the state, they say these injuries were made by a tail light. So those are the only two theories that have been presented at trial so far that I've heard about. But thank you again for the super chat. So the next witness, Richard Green, talked about cell phone forensics. And he started off really strong, but we're going to kind of see it breaks down a little bit. So he started off with that search, Haslon to dying cold. He's the source of that bombshell information that came out before trial that Jennifer McCabe, one of the people inside the house and related to the people who owned the house, that at 2:30 in the morning, 2:27 actually, she was searching Haslon to die in cold. It was a mistype. She obviously meant to say how long to die in cold. that's bombshell information, because if she's searching that, that means that at 2:27 in the morning, she knows that John O'Keefe has been left out to die in the snow. That would only come if Karen Reed had nothing to do with it, if it happened by the people in the house who left him out there. So at the fact that it showed up on the actual computer network or whatever they were looking at as being at 2:27 was really important. Now, the state says that's not when it happened. It happened that next morning. It happened at 6:24 in the morning with a similar search at 6:23. And it happened, Jim McCabe says, because Karen Reed asked her to search that. They had found John O'Keefe. He'd been lying there. He was very cold. And Karen said, Google how long it takes to die in the cold. And so she did. And she says she typed it in wrong once, and she typed it in still not quite right, but Haslam to die in cold was her second effort. And then she never finished that. I guess law enforcement arrived and there was just too much going on. So Richard Green is the source of that. And I'll talk about what the state's response was in just a minute.
An artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right, go on.
And actually, wait, a little more description before we get into this. Okay, so let me go ahead and tell you the state part so you can understand more about what he's saying. The state says, and they brought someone from the actual computer program that was used by Richard Green to determine that this search was really done at 2:27. And what this witness said, he worked for Celebrite, the company that made it, and he said, we had a glitch, I guess you would call it, in our software programming. And what happened was that this was this was when the tab was opened, and there was another search on the tab, and then on that same tab was a new search typed in, Haslam to die in cold. And the number it was giving you had to do with when exactly had to do with when the tab was open and not when the search was made. And that's why Richard Green got confused. The tab was opened at 2:27, but this search wasn't made until 6:23 or 6:24. The witness was very strong because it's his company. He even went so far as to say they had changed the entire software programming once they realized there was this potential to make a mistake like this, and to look back at when the tab opened and to think that that's when the search was made. So here is what the witness had to say about all of the differences. Oh, darn it. We're going to talk about two things. So that's the second thing you're going to hear. The first thing is going to hear relates to the clocks that are inside the programming. So go ahead and listen and we'll cover it all.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the three of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that, I think it's 3 minutes and 1 second, give or take a little.
Let me go ahead and stop it there and talk to you about what he's talking about there. One of the issues the state had pointed out was they said there was no possibility that John O'Keefe could have been at the house when his phone registered that he was going up and downstairs at 12:24, because he was typing into Waze, the Maps program, he was typing in 34 Fairview because he wasn't there yet. So this witness found a 3-minute difference in the various clocks that run on the phone. I think that was some really good work. We have not heard any real rebuttal of that yet from the state. So I think that was really good. Now you're going to hear him talk about the Haslam.
Opinion as to the timing of that first search for Haslam to die in cold.
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system, and comparing it to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time. Well, we know that that's in a
I mean, go ahead and stop it. So this witness also believes that Jen McCabe deleted messages. We've already heard from the state. They don't think that. They don't think Jen McCabe deleted any messages. It says deleted, but what they informed us was that doesn't mean deleted as in the user went in and said, oh, I don't want that message or this message. That could be harmful, and individually deleted them. But this witness is going to make a really good point about which exact ones are deleted.
deleted state. And
Are you aware of any internal mechanisms that could have caused that deletion?
no, not in this particular case. I know of no mechanism that would have done that.
And he showed a copy of the list of messages that she had sent. And there were a bunch in a row that were delete, 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 and then a bunch that were not. And it looked damning. Whether or not that will actually hold up in the response from the state, I don't know. So the expert, I did feel like the cross-examination of Richard Green did not go as well as Lally maybe could have made it. And a lot of it had to do with the fact that I think Lally stayed really too technical. And I think it'd be really hard for the jury to have any idea what he was saying. Here is a great example of that.
Rainy Min exhibit that we did, there is the browser. I'm happy to share those with you.
Give it just a second. That was Mr. Fine. We'll
Very
wait
good.
for this.
Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
I want to answer your question as well as I can. So can you repeat that one more time?
Sure. Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
So I'm having a little trouble answering this. So if I'm understanding correctly, when the wall file gets written to the database, and could that have made the change ending with this deleted record? Is that the question? I'm sorry. I want to answer you. I'm just
That's okay.
a little lost on how you're asking it.
Is it possible that the URL field, which has the website name, was updated to the newest search while the timestamp retained the original search? Is that possible?
No, not the way on this particular phone in this particular iOS, and also with the user interacted with it, that it would have been at the 227 or before. The way this very specific iOS was happening, that is consistent with all the other ones that I observed out there on the phone related to specific web searches and activity.
Okay, so let me pull that out and just talk to y'all. So you see what I mean? That was so technical. I don't think 1 in every 100 people have any idea what the question was to the witness. And I think that Lally had a good argument, which is the Celebrite employee himself came and says that not only, and he did kind of ask this, the Celebrite employee says, you're wrong, says they made such a mistake that people like you were getting confused, and they changed their whole program so people like you didn't get confused. And he came and told this jury that. Did you know that? And that wasn't the way it came out. It came out some really technical question related to the change request in the wall to the SQLite database pertaining to one particular field. I think everybody's like, what? I don't understand. Is the witness being contradicted? The only thing I thought with the witness being so confused, many people may say, well, he is supposed to be an expert. Probably he ought to understand that. But since I didn't, I couldn't fault him. It could be that Lally's question was really off, that it didn't really meet what the issues were. But I did feel like that just was kind of a missed opportunity, because I think the state has the upper hand on this one issue. I think that when the Celebrite employee came and said, we messed up and when you think it was done at 2:27, it wasn't, and we fixed the problem so that nobody else thinks that searches like this were done at the wrong time. That was a really, really strong argument for the state. Now, is that the only issue in the case? Far from it. But I thought on that one issue that they had a good argument, and it didn't really come out all the way with this witness. I thought it was difficult to understand. So we are going to go into our timeline next. I'm really excited to get to that. Let me go ahead and say a few thank yous. John O'Rourke is talking about an expert witness who doesn't see the wound in person, meaning, of course, Dr. Marie Russell, who didn't see the wound, but talked about it looked like a dog bite to her. And certainly that's the case, that she didn't see the wound and didn't have the same sort of up close information that the other two medical examiners would have had. One of them was more neuro, so wouldn't have been focused on this, but the main medical examiner, Dr. Scorti-Bello, would have. But it is true, too, that they didn't have the depth of information about dog bites that she did. And they hadn't seen, according to her, 700 different dog bites, and many of them would have been photographs for purposes of the study that she did and the paper that she wrote that then was peer reviewed. So I do think she had some extra information and ability to assess that, but that is a good point. She didn't see it in person and the other people did. So Kathleen, thank you. I appreciate very much the super sticker. And we've got anti-anxiety. I like that. A new member. Thank you. Okay, so let's take a look at the timeline, and I am super excited. Many of you know, because this is a work of love and art here. It is a timeline that the members helped me put together. We had a special members work group session, and they helped me figure out, okay, what are some things we need to include? And then some of the people who were members and who were at the session took extra work, did extra homework, and they actually have contributed to it more. So we will be going through this over the next days. Every day with testimony, we're going to add any new facts. And then I've got some special plans to do something on the third-party culprits and to look at some of the special issues where we can sort of follow the timeline and see what the evidence is. But so, okay, when I have new information from the day, I put it in yellow to sort of tell me what to look for as I'm talking to you. Let me make sure, is it big enough? Let me see if I can make that any bigger. I think I can. Let me try to make that a little bit bigger so you can see it better. That is probably going to be too big. Can I even fit that? How'd it do? Oh, that looked pretty good. Okay. So from 12:21 to 12:24, and this is the part I was trying to tell you about, that 3-minute difference that Richard Green, the expert for the defense, was talking about. So between 12:21 and 12:24, that's a critical, bizarrely small 3-minute window. John O'Keefe's phone shows he took 80 steps, 287 feet, and he ascended or descended, you can't tell which is which from the phone data, 3 flights of steps. What the defense says is that makes sense, because what happened was he got out of the car, he went into the house, went upstairs or downstairs where he was attacked, and he was walking and he was moving and he was climbing stairs. That 3 minutes, the prosecution says, could not possibly have been John O'Keefe doing anything other than maybe movements around the car, moving his arm, something like that, because he searched that 34 Fairview on Waze. That's why that 3 minutes mattered so much. If the clock said 12:24, but it really meant 12:21 because Waze was pulling from a different clock, maybe he really could have been there, really could have done the steps and could have done the stairs. That's what the defense argument is. So the prosecution says that John O'Keefe's cell phone arrived at 34 Fairview and stayed within 3 feet of where that GPS is for the rest of the night. Now, Richard Green said he put this information, the same data the state had, into several different programs, and no program could pinpoint that location to within 3 feet, that just isn't possible, that they made that up. And the state showed that at various times with the cell connection, it got broader or smaller, but it was the same location as the pinpoint for the rest of the night. What does the state say? Well, of course, they say that's because he was lying in the snow. He was in one spot. All right, let's see where our next yellow is. Okay. So this is the data related to Jennifer McCabe's search. At 2:27 a.m., we know that Jennifer McCabe searched for child's basketball team information, and Celebrite data presented by the defense shows she also searched that Haslon to die in the cold. Now at 2:45, just a little bit after that, and Jennifer McCabe was no longer at 34 Fairview, the snowplow driver passed by. He says he could see that entire Albert yard and he saw nothing in the yard. That is a little confusing because if he passes at 2:45, but Jennifer McCabe is already at home searching how long to die in the cold, then John O'Keefe must already be outside. Then from 3:15 to 3:30, snowplow driver Brian Loughran passes 34 Fairview a second time. Again, says he could see this time just about the entire Albert yard. He saw nothing. This is when he saw that Ford Edge parked in the street next to the flagpole and the fire hydrant that was outside the Albert home. He says he remembers it because he had to go around it. At 5:30 a.m., and this is another problem with his testimony, the snowplow driver said he started to plow Fairview again. He had to do this area several times, but he couldn't because first responders were on the street. But we know that the first responders didn't arrive until after 6 a.m. So the timing isn't exactly right. And is that our final? Nope, there's more. Okay, so on February 15th, the person named Paul, but is not Trooper Paul, approached snowplow driver Brian Loughran. Very interestingly, like with several other witnesses, law enforcement didn't contact him until sometime in 2023, which is when troopers Proctor and Butnick interviewed him. So we are starting to really see how that timeline helps us sort of put things together and lock things in place and see contradictions and problems and all of that. And it could not possibly have been done had it not been for the work of all of the people, all of the members who chipped in, who went back and did extra work and did all of the timelines for me and extra things that I hadn't pinpointed or hadn't thought of. So thank you to all of the members and to all of the people who worked on that. I'm very, very appreciative. Okay, so Matthew Pitzinger gifted 10 Lawyerly memberships. Thank you. All right, so if you would, we're ready for some questions. If you would, when you put your questions in the chat, if you would put several question marks at the beginning, it makes it a lot easier for me to spot it as the chat is going by sometimes kind of quickly to find everything. And John, I appreciate that. Can people rely on the iOS software? Fair question. I think there are problems with that. Certainly the time on my phone always seems proper and correct, but there are lots of things in that I think, for example, the movement seems really glitchy, like it often doesn't work or reads things that are incorrect, reads movements as steps or reads movements as stairs when they really aren't. I know sometimes I'll have my phone with me. I'll go up and down the stairs and it doesn't register that at all. Or sometimes I won't have gone up and down the stairs. Maybe I walked up the driveway and it will count that. So I think there are some questions. I think that's definitely fair. Okay, so let's head on over. I'm going to look for the questions over here. I'm looking for, okay, here we go. Lots of, I think I see. Yes, there it is. Okay. So looking for the question marks at the beginning here, and I see Shara wants to know why about no car data. They said that the prosecution said they tried to pull data from the vehicle, Karen Reed's vehicle specifically, and they weren't successful. There wasn't a lot of maybe I should say, there may have been enough understanding that some people could have understood it. I didn't really get why they couldn't get more car data than they did, but they got pretty much not a lot. So you would think they could have tracked it, but for some reason they weren't able to do that. Jay Banks wants to know whether the defense will call a rebuttal medical examiner. I do think they have somebody in mind to talk about that. They mentioned that they have some, when the court said, I'm not going to let Dr. Marie Russell talk about the issues related to this not being close to or connected to a pedestrian vehicle strike. I remember that Jackson said, oh, that's no problem. We've got somebody for that. We only need her to talk about the dog bite. So I think that that may well be something that they have lined up. I think they will have somebody to talk about that, Jay. Okay, looking for question marks. Zelda, do you think the jury will be given a timeline? Nope. Like what I'm creating here. Do you think Karen will take the stand? So that's a no and a no. I don't think they'll be given a timeline like this. I don't know why more lawyers don't do this. It really is helpful. It's a demonstrative exhibit if you're at trial, and it's hard to get every little fact in. You have to argue over that and whether you've said it just right. So what we're doing here, that would be way more than you could ever present to the jury. Also, they wouldn't be able to take it out with them because this is not actual evidence. It's something that someone else has put together about the evidence. So they won't get anything like this. Hopefully someone will help them weave it all together with the closing arguments at a minimum. I think it really helps. And I always do a timeline in my cases, even if it's not this detailed. Do I think Karen will take the stand? I think it would be a huge mistake for her to take the stand. And no, I do not think she will. I don't always say that. You know how lawyers always say, you know, the defendant should not take the stand. Absolutely not. You can do nothing but get in trouble. I don't really think that necessarily, especially for someone who's facing life in prison. You can either spend life in prison thinking, dang, I said the wrong thing, or you can spend life in prison thinking, why didn't I speak up for myself? And I think that really has to be a decision made by the defendant. And I think lawyers kind of jump in there a little too much. But in this particular case, the defense has done a phenomenal job. I think they well may have convinced a juror or two or more that there's at least a question as to whether there's reasonable doubt. It would be crazy for her to testify. It would be nothing but downside for her. I cannot imagine her doing that. And she said when she was asked as she was leaving the courthouse, she said, well, I'd love to get my story out there, but I'll defer to the lawyers, which I think just means when I don't testify, I'm going to know that I wanted to get my story out, but I don't think the lawyers will allow that. I think that would not under no circumstances in this case. I think this one's an easy call. Denise, why do you think the last question was excluded from the dog bite expert? The name is Marie Russell. Denise is asking what the name was. As far as I can't remember what the last question was. I think the last question might have veered into what she was excluded from testifying about. And she was not allowed to testify about whether or not the body injuries were consistent with a pedestrian wreck. She could have been named for that, but the court didn't allow it. She wasn't named until really late in the game. So the judge just let them get the part they really needed from her and that they did not have anyone else to talk about. So that was probably what it was. I can't remember for sure, but I'm thinking that's what it was, Denise. Destined to be. Oh, I like that. What happened in 2023 that causes them to start questioning everyone? It was the federal grand jury investigation, I think, and that got everybody moving again, like, oh, maybe we should investigate a little more. That's what I think it was about. Okay, Diane, who does a random search for how long does it take to die in the cold? Very odd. And that would be odd. And I think the defense would say she did that because John O'Keefe was out there. But I personally am not really convinced it happened at 2:27, not only because of the Celebrite testimony. I thought he was really strong, but also because it does seem really like a strange, you would have to be very, very cold to be like, oh, you're at home, someone is dying out in the snow, and you search, oh, what's the basketball schedule for my kid again? Oh, and just out of curiosity, how long would it take to die in the cold? I do think that you would have to be really cold to do that and then not even finish the search. Oh, I don't really care. and you just put it away. That seems, I mean, that would be really, really, really horrible if someone did that. That's all I can say. Christine Foster, isn't Apple Maps off enough? Sometimes it directs people in the ocean. Yes, I personally have been directed through a field before. Thought, wow, should I do that? And I actually started and I thought, I am not going to do that. There is no way that field is, I'm supposed to cross that field. Mark Chandler wants to know, it probably doesn't matter, but they state the Lexus weight is over 7,000 pounds, but it wasn't. It's closer to 5,500. Oh, that's interesting. I didn't know that. They did say 7,000 pounds, Mark. You're absolutely right. They said that. Mimi of 2 wants to know, who is the owner of the Ford Explorer? I don't know. I don't know what did Brian Higgins have a Ford Explorer? I don't know. I remember he talked about how he had a snowplow on the front, but I can't remember what vehicle he drove. It's probably in our timeline. So I'll look that up after we finish. Oh, Ford Escape. That might have been Brian Higgins. Stephanie is mentioning it might have been that. Andrea, what if they let the dog out and the dog was trying to help? Although I did think about that. Like, what if the dog finds him, because they did make a point of saying they had let the dog out earlier in the backyard, and maybe somehow the dog got into the front and was trying to drag him to safety or trying to wake him up and was concerned about him. I mean, I guess that's possible. Then that may be what the prosecution is going to argue. We'll just have to wait and see. Loves my angel. John O'Keefe need not have already been outside when the Googled hustle. Oh, interesting. Maybe they were trying to work out what to do with him. Now, that's an interesting point, Loves my angel. That is very interesting. Okay, so maybe that's what the argument will be. I appreciate that thought. Oh, also, John O'Rourke is a new member. Welcome. Glad to have you. So, okay, I told you I was going to give you additional of the AI stuff. This one I thought was so funny. This is summaries of what was going on in the live chat that I was watching today. It said, the ongoing live chat is about a court hearing of Lally, who is the prosecutor. People are discussing his behavior, such as smoking excessively, his relationship with Chandler. Like, who is Chandler? And the possibility of him being under the influence of drugs in the courtroom. Like, wow, where was the chat getting this? Because I don't think there's any allegation remotely like that in this case. And certainly this seems pretty scandalous to be suggesting that the prosecutor is using drugs during the trial. I don't know where they got that. So if you see any of these, please, that are really kind of funny. If you just refresh, it gives you the summary. I just do it I do it over and over just to see if there's kind of a funny one. So if you see one of those and they're really funny, please send it to me, because who doesn't need a little cheering up? You know what I'm saying? So I have really, really enjoyed that. Regina, thank you very much for the super sticker. Okay, well, I will take 1 or 2 more questions and we will call it then. Let's see what Lorna Doone says. Did the prosecution offer an explanation of why no one would have seen him on the ground when leaving the party? It doesn't seem long enough for him to be totally buried by snow. I think that's probably true. There were various questions asked of the witnesses. Like, one witness said, I was talking to my boyfriend. I think that was Caitlin Albert. And another witness said, one witness said, I saw something over there. And I said, hey, I think I see something, but no one was really paying attention. And I thought, I'm drunk. I probably made it up. So I think that they sort of tried to dismiss it one person at a time, that they weren't focused on it or thinking about it. So they didn't look over there. And my Nick wants to know, did the FBI give everything they collected to the defense, or would they still have things that neither side was given? Yeah, very possible, my Nick, that there would be information they have that the two sides weren't given. I'm guessing they gave most of the information they had. And it sounds like they gave the full transcript of the hearings to Karen Reed's team. They obviously disclosed who the experts were, disclosed the reconstruction, because those are the very experts who are testifying in this case. So I think that there's definitely been communication. Is it 100%? I don't know. The FBI didn't have a duty to give that. least probably not. I'm assuming that there was no request for that they had to comply with, and it was in the middle and still probably sealed. So I really can't imagine that would have been something that happened. So I think it was just voluntary, and I think they've turned it over. So I will see you all on Monday night at 7 p.m. Eastern for our regularly scheduled show, and I will see you then.